putting a bench there, which neither Colerain nor Sorda seems obligated to do. So we don't think we are a safety hazard. We're certainly not affecting the general welfare or whatever public health, safety, welfare of Colerain. They've singled out our benches as a public nuisance. Now, on the constitutional issue, which I think is huge here, the Central Hudson case, which has been adopted by the Ohio Supreme Court in Norton, says there's a burden is on the government, not us, on the government. When you've got free speech and bench advertising is First Amendment speech, that when you have free speech, that they have to meet the four-part Central Hudson test. They don't. They don't meet that. Number one, because of the plethora of signage. If you drive up and down Colerain Avenue, it's like signs on steroids, which is what Kathleen Ryan found. They allow billboards that are 150 square feet and 40 feet off the ground. The bench, the little bench billboard has 12 square feet of advertising and it's about 4 feet off the ground. It's hard to find them if you drive down Colerain because of all the other signage. So our constitutional argument is that they don't meet the Central Hudson test because the regulation prohibiting just bench signs does not directly advance a substantial governmental interest because they've shown that they really aren't that much concerned about the proliferation of signage on Colerain. If they were, then it'd be a tougher argument. So what they've done is they've allowed 150 square foot signs and they've decided to prohibit just our 12 square foot sign. And 12 square feet is something that small businesses can afford. They can't pay $5,000 to put a sign on a 150 square foot billboard. So constitutionally, I think that the prohibition of bench advertising signs is a violation of the First Amendment as well as the 14th Amendment. But so the final point I'd like to make is they've argued that we have not exhausted our administrative remedies. That argument only applies to the benches on public property, not private property. There's no issue about there's no issue about exhausting administrative remedies on private property.
Well, what's in the record regarding the private property? Are there licenses or lease agreements, or what's in the record regarding the private property benches?
When we place our benches on private property, we do so with the permission of the owner of the property. We have benches in Colerain Township prior to 1977. That's before their zoning code, which is 1994. So those benches, according to Judge Tracy, are legal non-conforming uses. The fact that Colerain in 94 decides to prohibit our benches doesn't change the fact that they are legal non-conforming uses.
And it's your position that 1994 order from Judge Tracy applied to these benches in Colerain Township?
Absolutely, because Colerain Township is in Hamilton County. And her ruling, although Colerain was not a party to the lawsuit, I understand that, but her ruling applied to benches in Hamilton County. And Colerain Township in Hamilton County, when they adopted their zoning code in 94, we were a non-conforming use in Hamilton County before they adopted their zoning resolution. So we clearly, and I think that's you can't argue that. I don't believe the administrative appeal on the public. I'd like to touch on it quickly. I'm sorry.
It's my understanding that that Judge Tracy's order specifically exempted the benches in Colerain Township. Is that incorrect?
I believe so. I think what she said was that she was not addressing specifically the benches in Colerain Township because they were not a party, but her ruling applies to benches in Hamilton County which Colerain Township is part of. So her finding of a non-conforming use doesn't have anything to do with whether or not Colerain was a party. Her ruling is that benches, BBC benches in Hamilton County under the Rural Zoning Commission prior to 1977 were legal non-conforming uses. And I don't see how Colerain can get around that, because in 94, when they adopted their ordinance, they basically were in Hamilton County. So it was a prior establishment of a non-conforming use in Hamilton County. It should cover Colerain.
Let me ask you about the private benches as well as the public benches or benches on public property. I thought there was a provision in the Colerain Township zoning code that recognized that billboard or bench billboards were a non-conforming use, but there was also a provision whereby bench billboards could apply for a non-conforming use permit or a certificate or something along those lines when Colerain Township adopted its own zoning. Am I mistaken in that, or is that the case?
Yes, because what Colerain did was they declared that portable structures cannot attain non-conforming status, and they defined our advertising benches as portable structures. So, and I can look up the section, but they basically dictated that our benches could never be legal non-conforming uses by their ordinance, which I believe is illegal.
Okay, thank you.
You are at your time if you'd like to reserve your rebuttal.
Yes,
time.
I would. Thank you.
All right, thank you. Mr. Solomon?
Yes, for the record, Scott Solon on behalf of Appellee Colerain Township. And I'll go ahead and quickly just get right to the Hamilton County Judge Tracy holding. On or about October 11th, 1994, the Hamilton County notified BBC that 42 of its benches, including 21 located in Colerain Township, were in violation of their zoning resolution at that time. On September 1st, 1995, that's when Judge Tracy granted that partial entry and decision in that case as to some of the BBC benches at issue in that case, and with respect to Hamilton County. But one thing that is important in that case is that Hamilton County and the counties that were and the townships that were left in the case agreed that those bench billboards had been in place prior to that 1997 amendment to the Hamilton County zoning resolution, which removed permanent component from the definition of structure. It's not applicable in this case, and they're assuming it's somehow relevant and applicable with respect to the benches at issue in this case. But that is, again, despite explicit language, which clearly holds otherwise. The partial entry and decision, the court holds that the parties agree that the issues in this litigation, right? We don't agree that those bench billboards at issue in this case were there before 1994, let alone 1997. And
so is it your position that Judge Tracy's order has no bearing on the issues in front of us right now?
Exactly. You can read the language. It says they only pertain to those 21 benches now situated on non-residential property outside of Colerain Township. And, by that time, Colerain Township had already put in place its own zoning resolution in 1994. And so the entry and decision are clearly not applicable. Even the agreed entry that resolved that case talks about different townships where some of those bench billboards were allowed to get permits, non-conforming use certificates. None of those, Colerain Township is not one of those 7 townships involved. And probably the most damning evidence in this case actually comes from BBC's own attorney back then and still now, Mr. Hozaffel, who wrote correspondence on behalf of BBC to Colerain Township on February 13th, 1996, that states, here's what he talks about with respect to the aforementioned, the Hamilton County litigation, how it did not involve BBC bench billboards within Colerain Township. Early in the litigation of this matter, it was determined that the benches cited in the October 11th, 1994 letter that were located in Colerain Township could no longer be included in the lawsuit or settlement discussions due to the fact that Colerain had adopted its own zoning code in 1994. Therefore, although Bench Billboard Company and Hamilton County have reached a settlement agreement regarding most of the benches in Hamilton County, the issue of placement of benches in Colerain Township remains to be decided. This is from opposing counsel's own correspondence. And therefore, as of February 1996, I think it's irrefutable that BBC had not established any kind of legal non-conforming use. There's a big difference between non-conforming use and a legal non-conforming use.
So Mr. Solomon, walk me through this. So how does the BBC, how do they get their benches to conform? What's the process? What do they have to do to keep these 5 benches in the public right of way in Colerain Township?
What do you mean? To keep them in the right of way? They can't. They, I think it's pursuant to the statutes. The township is allowed to go ahead and enforce resolutions and ordinances which utilize police powers. And that's exactly what happened in this instance with respect to resolution 63.14.
What about the application for the non-conforming use? I mean, I heard almost a futility argument by opposing counsel as to why they didn't go down that path.
Well, he said it was futile because the benches weren't allowed, back in, from when the implementation of the 1994 Colerain Township zoning resolution, he's correct. Immediately, bench billboards weren't allowed. That being said, he had 30 days at that time to go ahead and it said, if you wanted a non-conforming use, you shall, the language was mandatory, apply for one. And if he would have applied for one and shown that they had been there prior to the implementation of the 1994 Colerain zoning, then he could have got a non-conforming use certificate, and we could have documented it, and we know where the benches are and should be now. He never did that. They never did that. Even despite a 1994, I think, a violation that was issued way back, after our Colerain implemented its zoning resolution, BBC never appealed that. And pursuant to case law, there's a case out there that says if you fail to go ahead and take advantage of being able to, it says when a zoning ordinance or resolution requires that non-conforming use be registered within a certain period of time after passage of the ordinance imposing the requirement, failure to comply with the time limits precludes the owner from arguing that the use is a valid non-conforming use. And that's a case, Eastep versus Liberty Township Board of Trustees, that's cited in my brief. They never did that. There's not even the assertion that they ever applied. They've never applied.
Let me ask you this question. So that seems to be the grounds that the trial judge denied the deck action and the injunctive relief. Certainly as to the public, but what about the private property, which Mr. Hozoff will raise?
Well, he talks about the public and the private property, and initially, he's correct in the fact that the township did pursue with respect to bench billboards in the right of way, in the public right of way. That was our intention, was to go ahead and clean up Colerain Township and get that and address that. He talks about public-private, but I don't know how he can distinguish the two, because the reality is the only survey expert that any on record that's ever been done in this case is Steve Rhodes, the township's expert, who only surveyed the billboards at issue on Colerain Avenue. These other ones, who knows if they're on public or private property or the public right of way? We don't know.
Are you saying the record doesn't distinguish what's on public versus private?
Only with respect to the 9 billboards that were on Colerain Avenue that expert wrote took a survey on.
So let's say that I live in Colerain Township and I have a house that is alongside a busy road, and I want to make some extra money, so I have one of these benches put on my property. Can Colerain Township come in and say I can't do that anymore because it's a nuisance?
Well, I would say that all the people I've talked to, first of all, there's no evidence that there's any kind of lease or if it's in the right of way. If it's on private property, it might be a different violation of the code. I'm not familiar with it, but all the people I've talked to, the evidence in the record, whether, these people aren't getting asked if they want these bench billboards on their property. They just end up there, and they think that because they're next to a bus stop, that somehow the township's putting there or the bus stop's putting there. Most of the business owners I talked to in Colerain Township want these things gone. And, I tell you what, if I'd be very comfortable saying if it was left up to the actual property owner, because keep in mind, Bench Billboard Company owns absolutely nothing. None of this land that these benches are on.
What if it's just a bench and not a bench billboard? Does that change the analysis?
As far as it being the right of way, probably not. But if it's, if you're advertising, then it's a different use. If it's a residential area and you're advertising for commercial, that would probably be deemed a different use. So you can only have one use.
That seems to bleed into their constitutional argument, because then it sounds like you're doing it just for purposes of suppressing speech, according to
they can still, there's billboards, like Mr. Hosoffel said, there's a lot of different means they can go ahead and advertise on Colerain Avenue and in the township. We're not saying that you can't advertise anywhere else. I think you have to look at that. I think the case that Judge Mock talked about with respect to Covington hits that on the point, as far as, whether or not there's a violation of constitution right there. In Bench Billboard versus City of Cincinnati, this court held that the City of Cincinnati's ordinance regarding bench billboards in the right of way was constitutional, and the stated purpose to regulate the placement of structures within rights of way in order to protect the safety and ensure adequate clearance for pedestrian traffic was not arbitrary and unreasonable, but rather the ordinance was proper police power which bore a real and substantial relationship to the health, safety, and general welfare of the public. And in my brief, I compared the City of Cincinnati's ordinance, those stated purposes, with also the stated purposes of the resolution 6314 in Colerain Township. And they're very similar in the fact that, the resolution 6314 states that it's to protect the public and ensure protection of travelers and the roadway and the pedestrians as far as furthering township aesthetics. With respect to, I think with respect to the injunctive relief requested pursuant to, I think 519.24, which essentially all we have to do is show, require that to show that property was used in violation of the township zoning laws. And we're not required to show or establish irreparable injury or there's no other adequate remedy at law because of the fact that it is a statutory injunction. That's undisputed. Steve Rote has said, hey, he's taken a survey. He's found that multiple bench billboards are in the right of way of Colerain Township Road. So I think that was proper for the court to go ahead and find that there was no question of fact, because none of it is refuted. As far as the counterclaims go, with respect to requesting, declaratory relief, as far as the BBC benches being prior legal nonconforming uses, and or that they, resolution 63 and the 14 and Colerain zoning resolution are void or unenforceable, or the injunctive relief requesting that those not be enforced and that they violate free speech and equal protection. I think there's case law that says they have to exhaust their administrative remedies, and they've never done that. And there's no dispute of that. They just say that it was unfair. Well, they could have presented all their evidence to the BZA and at that point, but they've never done that. They've never taken those steps. There's no evidence that they ever appealed, and this is important because at that point, then it puts, pursuant to Palmer v. Gray, which is a case very similar to this. It was a township that ultimately precluded, or the township brought an injunction against a landowner and with respect to gravel roads. And in response, the defendant counterclaim with a mandamus, a declaratory judgment action, and a takings claim, which is a constitutional claim regarding the use of that gravel driveway in violation, and the court in that case held that because the landowners did not seek a variance or avail themselves of administrative remedies prior provided by a township zoning commission, which is what this, they could have utilized the Colerain Township BZA, which specifically offered the right to those appeal. They were precluded from, making those claims. I would say the only thing that might distinguish that case is the fact that in the Palmer v. Gray case, it actually involved the landowner. In this case, the bench billboards, they don't own any of the land that they're situated on. And, they're alleging non-conforming use. I think there's even a question about whether non-conforming use, it runs with the land. That's what the case law holds. So, with respect to the free speech allegation in Bench Signs Unlimited versus Lake Township Board of Zoning Appeals, that was a township zoning resolution that prohibited advertising on bench signs. That was found to not be an unconstitutional restriction on commercial speech because it served a substantial government interest because it kept the right-of-ways clear and the township aesthetically attractive and prevented obstruction of views of the motorists and distractions. And that's the same thing. It's right on point with this case. The truthfulness of the content of the bench signs is not at issue. We have no issue with what's actually on the advertising. It's the fact that it's in our right-of-ways, preventing, obstructing views of the motorists. And there's testimony from, as far as nuisance, there's testimony from different business owners that's in the brief that talks about the garbage that collects and the fact that there's other issues as far as, they found drug needles and other problems, people sleeping on the benches, people, that type of issues. And also to the contrary, there's testimony on the record that says when that bench was removed, those issues stopped. In addition, there's a testimony from BBC's own independent contractor, Steve Marks, who said, now, while not in Colerain Township necessarily, but in Hamilton County and other places that they have these benches, cars have been in accidents which have involved these bench billboards, and they've been wrecked into. While they're on the sidewalks and whatnot. So there's a clear, substantial government interest in keeping these off the right of way. As far as an equal protection allegation, to show that, you have to show the government officials we're somehow treating them differently from a similarly situated person, and that the government is unequally applying the laws or the statutes for the purpose of discriminating against them. Who is the other similarly situated entity? There's no identification of that person. They have not satisfied that element at all. And then as far as, they've also failed to show the unequal application of the zoning resolution. I think if, other cases, there's bench bills. And I also want to talk about the Roschke letter, which one thing that opposing counsel fails to acknowledge is the follow-up. That Roschke letter was on September 6, 2007. And October 3rd, 2007, the former law director for Colerain Township wrote a letter to Mr. Hubzoffel telling him at the time the letter was written, Dr. Roschke did not have access to the documents in this case. For some reason, the case does not appear on the Hamilton County Clerk of Court's website and therefore did not have the benefit of the Judge Martin's decision entry filed on August 3rd, 2007. We have that judgment entry now. Since the various assertions made by Ms. Seward that her existing benches were entitled to non-conforming use status were fully litigated by the parties and a final judgment rendered against the defendants, Dr. Roschke's letter is withdrawn and of no effect.
Mr. Coleman, I'll give you a few more seconds, sir. You are at your time. Is that letter part of the record?
Yes, it's part of the record. I believe it is Defendant's Exhibit Y. I think it's actually contained in the brief, Your Honor.
Thank you.
In the footnote, actually. As far as the other counterclaims, governmental immunity, we raised that issue. There's plenty of case law that talks about, conversion, tortious interference, negligence. You can't get punitive damages against a political subdivision. BBC doesn't attempt to even establish any exceptions to that immunity. And, with respect to the conversion claim, there's testimony from Gromlich that they got their benches back. So they can't satisfy at least one of those, that element for sure. But with that all being said, Your Honors, thank you for your time, and I appreciate it. And I would request that you affirm the decision of the trial court with respect to granting a summary judgment in favor of the township. Thank you.
Thank you, counsel. Mr. Hosoffel, you still have your rebuttal time, sir.
Thank you. Well, Mr. Salmon continuously conflates the private property and public property. They're two entirely different things. The administrative appeal issue only relates to public property. We never got any public notice on private property that would generate any claim that we needed to appeal to the Board of Zoning Appeals. Never happened. So it's totally different. The public property involves certainly Susan Roschke's ruling. She was a zoning administrator for Coleraine, and then they tried to walk it back, but what she said was in keeping with an agreement that Bruce Gromlich had with Toby Braverman of Coleraine. So, and the resolution that they adopted even referred to the fact that there were non-conforming uses on public property. So now the fact that, let me address this thing next. 15.12C states that portable signs shall not be designated legal non-conforming and shall be removed. So there, by ordinance, they've declared our non-conforming signs to be not non-conforming, which of course makes an appeal to the Board of Zoning Appeals entirely futile because, number one, the ordinances which they are to interpret clearly prohibit us from public and private property, and their own zoning code says we cannot ever be a non-conforming use because they've determined that we are by definition portable. So that's clear. It's from their own zoning code. On private property, they have not offered anything that says that our benches, forget Judge Tracy's ruling for a minute, they've not offered anything that says that our benches in Hamilton County and Coleraine Township before 1994 were not legal. They've offered nothing to say that they were not legal. So if they were legal, as Judge Tracy opined, before 1994 adoption of their ordinance, they continue to be legal, and a municipality or township cannot, by dictate, eliminate a legal non-conforming use. Now, Judge Tracy's entry and decision doesn't draw the distinction. There was a subsequent agreement between the parties, and Coleraine wasn't a party, so they weren't part of that. But her decision says, and I quote, consequently, with respect to those benches which predate the 1977 amendment, that's the Hamilton County Rural Zoning Commission amendment, they do not fall within the definition of structure and are therefore not buildings or otherwise subject to the prohibition of placement of objects within 30 feet requirement set forth in the code. She doesn't say just in areas outside of.
But what about the point, and I'm looking it up and I can't find it in the brief right now, but that the order specifically carved out Coleraine Township?
The entry and decision did not. The final agreement and order, there's two documents, Your Honor. I'm reading from the entry and decision. There was a subsequent order that went in that she signed, but her entry makes it very clear that benches in Hamilton County rural area before 1977 were legal non-conforming. The Coleraine, it seems to me, they say, well, that doesn't apply to us. Well, yes, it does, but they need to come forth with some argument that our benches were not legal. We have an argument from a judge that says we are. They have nothing that says they weren't. So if they were legal, if they can't show they were refute our argument that they're legal before 1994, then they're legal non-conforming uses. On the constitutional issue, it's clearly, as was noted, it presents their prohibition of just the 12 square foot bench ad and allowing 150 square foot billboards clearly raises Central Hudson constitutional issues. Does the elimination of a 12 square foot sign 4 feet above the ground directly advance their argument that as to signage, that there is some general welfare, safety, health, whatever benefit to eliminating just the littlest sign on the block? We have no problem, says Colerain, with a 40-foot high, 150 square foot billboard, but we've got a problem with the little 12 square foot billboard. And I don't think that eliminating it's under inclusive, if anything, eliminating the smallest sign doesn't directly advance any interest. If they wanted to directly advance an interest as to proliferation of signs, they would restrict the number, the size, whatever. But if you walk down Colerain Avenue, you're overwhelmed with signage. And Kathleen Ryan, our expert, I'm sure somebody has read that report, very clearly points out that they have no justification for eliminating just the bench sign.
Mr. Hudson, you have reached your time.
Okay.
Thank you, counsel, both of you very much for your arguments this morning. Case is now submitted. Obviously interesting arguments. We will review the record and issue a timely decision. Thank you.
Thank you, Your Honor. Appreciate your time.
Everyone have a good day. Thank you.
You have a good day also.